OSCE mission to Bosnia and Herzegovina in 1996. She is also a board member of the Visafia Choice, an NGO that supports survivors of conflict-related sexual violence. Sandra Letterman-Winterberg is the Vice Director of Directorate of International Law within Switzerland Ministry of Foreign Affairs. Her division oversees international humanitarian law, human rights law, and the rule of law, with a particular focus on counterterrorism law and a diplomatic and consular law. Sandra has held various diplomatic positions in Switzerland and abroad, and has led to several years Switzerland's Human Rights Diplomacy Office. Sandra has a professional background in dispute resolution and international trade law, and serves as the president of the Swiss Women's Diplomatic Association. And Professor Ruth Halperin-Kadari, which is a great friend of mine and is a co-founder of the Dinah Project and an expert on family law and international women's rights, and is the founding academic director of the Rackman Center for the Advancement of the Status of Women at Bar-Ilan University Law Faculty in Israel. In December 2018, she completed 3 terms of being a CEDAW committee member, on which she served twice as a vice chair of the committee and as the first chair of the working group on inquiries. She is a recipient of numerous research grants and international awards. So thank you all for joining us. I'm very excited to start. And Erin, let's start with you. You have extensive experience working directly with victims of atrocity crimes. And your work with the Red Line Initiative focuses on advancing justice for survivors. Can you please share what the initiative is about and what is the short-term and the long-term goals for the initiative?
Well, thank you, Tal. And before I answer your question, I do just want to say how grateful I am to be a part of this important conversation, and to thank the hosts and the co-hosts, IWN and the Dinah Project. As you mentioned, I am the Senior Legal and Policy Advisor with the Dr. Dennis Mukwege Foundation and lead the work on the Red Line Initiative. The Red Line Initiative is inspired by Dr. Mukwege, the 2018 Nobel Peace Prize laureate's call to dramatically rethink how we approach conflict-related sexual violence, to not look at it as a very unfortunate but inevitable consequence of war, but rather something that should, must, and can be prevented and responded to. And so what the Red Line Initiative seeks to do is to understand what are the impediments. Is it a gap in the law, or is it a gap in implementation? And so what we undertook was a multi-year process of working with the relevant experts, of compiling all of the applicable law with regard to states' obligations for conflict-related sexual violence. We compiled what is called the Guidebook on State Obligations for Conflict-Related Sexual Violence, and I'm just going to put a link in the chat. But basically what it looks at is international humanitarian law, international human rights law at both the international and regional levels, as well as binding resolutions of the UN Security Council, to see what states are obliged to do under each of these legal frameworks across 4 thematic areas: prevention, justice and accountability, response, and reparations. What we found, Tal, is that in fact there is an incredibly robust jurisprudence of law and obligations on states, but there is a tremendous knowledge and awareness gap, which is in part due to the way that much of this jurisprudence is placed in the public sphere. It's very inaccessible and it's very dispersed because there is not one centralized place. So that is one of the goals of the guidebook, is to compile in one transparent, accessible place all of this jurisprudence, setting it out in a way that it can be accessed. And the audience of the guidebook is first states themselves. that they understand what their obligations are, as well as the scope of those obligations, which is quite detailed, particularly under international human rights law and the work of the expert committees, such as what Ruth was involved with the CEDAW expert committee. But the other part is to where states are not willing or perhaps even unable, is to provide a tool for civil society, and more specifically for survivor groups themselves, to be able to use this information in terms of what states are legally obliged to do in their interactions and advocacy with states. It is meant to provide a tool to address the power imbalance that many survivors face when they interact with their government, which is simply to say that this is not something that states are being asked to do out of the goodness of their heart. It is not charity. It is a legal obligation to which they are bound. So with that, that's a very brief overview. And as I mentioned, I have put the guidebook itself in the chat, and I would certainly encourage everyone to visit for more information.
Thank you, Erin. That's really interesting. Israel Women's Network and the Collective of Women in War published a report in the absence of the state action to prevent and to effectively respond to CRSV of October 7. So we found that it's very important for states to involve civil society and the public in general in many stages of the process of obtaining justice for all victims. So thank you for that. And building on that, one of the key challenges in addressing CRSV is ensuring that states take responsibility for pursuing justice. So in your view, what obligations do states have in this regard? And if you can maybe put into more of a context of what are the steps and what should be done?
Yeah, so maybe when we begin with, international law, for it to be actionable, it has to be domesticated at the domestic level, right? So one of the first things is the domestication of the crimes themselves. That means ensuring, for example, that your national legislation in your criminal code for the definition of sexual violence, for the definition of rape, comply with the international standards. So, for example, you do not have to have, and you actually should not have, a overly restrictive definition requiring force, as just one example. Certainly in the context of conflict-related sexual violence, which is an inherently coercive and threatening environment, there should never be a requirement of evidence of physical force and lack of consent in the way that we would prosecute domestically. The second point is that the law must recognize the modes of liability and provide for criminal accountability for superiors and those who issue commands. This also is important for survivors because it moves the investigation away from requiring a tremendous amount of evidence from the survivor themselves, and actually looks much more at the hierarchy of the armed group or armed forces and the orders that were issued and the manner in which they were implemented. So this is also important in terms of understanding the distinction between conflict-related sexual violence and domestic sexual violence and domestic rape. The other thing that I would just highlight, and this comes actually from CEDAW specifically, but it is found throughout the general recommendations, commentaries, and decisions of various human rights expert committees, is that states have an obligation to prior to conflict happening, prior to conflict-related sexual violence happening, to ensure that the capacity of not just law enforcement, but also security services, medical services, and judicial personnel are trained in best practices in collecting and preserving forensic evidence. And this is in relation to ongoing conflicts as well as in post-conflict settings. States also have an obligation to work with civil society and international investigative mechanisms in the collection of evidence to ensure that the most potential avenues for justice can be pursued if wanted by survivors. And maybe just as one very final point is that one of the other obligations that states have in terms of conflict-related sexual violence and the specifics of it is to ensure that investigations are carried out in a gender-sensitive manner. This means ensuring that you have the human resources, the personnel such as specialized units at police station, women police officers and investigators who can conduct interviews if that is something that a traumatized survivor needs in order to be able to feel comfortable accessing the justice system.
Thank you so much. Actually, as an executive director of an NGO, I'm particularly interested in the role that civil society can play in holding states accountable. So can you share an example of how NGOs have successfully mobilized state actors to fulfill their obligations?
Yeah, there are a number of examples. There are a number of examples of civil society really standing as allies and amplifying the voices of survivors themselves and working collaboratively with survivors to make change that reflects the needs and priorities of the survivors themselves. One of the examples I would just highlight is what has happened recently in Ukraine with the introduction of legislation providing for urgent interim reparations specifically for conflict-related sexual violence survivors. This is incredibly important when we understand the degree of time that criminal prosecutions can take, obviously in an ongoing conflict such as Ukraine. The fact that Ukraine has moved this legislation forward, but very much at the with the sort of lead being survivors and civil society jointly pushing the government to do this. But the fact that this is happening during an ongoing conflict, that Ukraine is already positioning itself to respond to the harms that conflict-related sexual violence survivors have suffered, to repair those harms, is an incredible, somewhat unique example of timely response that a state should take. So that's just one example. And I know that Tanya will probably speak about the example both in Bosnia, but also of Kosovo, of tremendous work by civil society with regard to children born of rape. So there are a number of very concrete examples of civil society, when they have the information, being able to push states to do much more and actually meet their obligations.
Wow, that's very inspiring. Thank you, Anne. And so now let's turn to the state's perspective. So Sandra, as a representative of the Swiss government, Switzerland has been actively engaged in the intersection between CRSV and counterterrorism. Can you share what drives Switzerland's interest in this issue?
Thank you very much, Tal. Thank you very much for having me, and I enjoy hearing and congratulating you on setting up this panel today. Yeah, I'm the only state representative in this panel, so there's quite some pressure on me, and probably the least expert on the field. But Switzerland has a long history on working on accountability, of course, mainly in the framework of the Geneva Conventions. My division is also having the role of being the counterterrorism coordinator, which gives us the privilege of having quite a broad view on all different thematics. Working on that and focusing on the rule of law and accountability matters in particular, sooner or later you just come across the issue of sexual and gender-based violence, SGBV as we call it, and the interrelation between counterterrorism and SGBV and prevention of these crimes. As a government, we are part of the Global Counterterrorism Forum. It's a regionally, it's across the regional, but still rather exclusive circle of states focusing on counterterrorism and rule of law issues. And in this format, we were chairing a group working on criminal justice and rule of law together with Nigeria. And we established a memorandum on criminal justice approaches to look at the interlinkages between terrorism and international core crimes, sexual gender-based violence, human trafficking, migrant smuggling, slavery, and crimes against children. So you see still narrowing it down, coming from accountability in armed conflict to terrorism, to sexual and gender-based violence, and still interlinked with other issues, and in this still limited group of states working in the global counterterrorism forum. So that was still a very limited lens, but which provided states to exchange in a safe format, share best practices, but also share challenges and develop a set of recommendations we would aspiring to work on, but all this on a very voluntary basis and on a best practice basis, so to say.
That's very interesting. And building on that, recently the UN Counterterrorism Committee, the CTED, issued a report titled Towards Meaningful Accountability for Sexual and Gender-Based Violence Linked to Terrorism. So can you share some of its key findings and the policy recommendations for states?
I'm very happy to do so. So coming from the GCTF and this excluded group, it was taking it next level, taking it on the UN level, having a very frank discussion with all texts and having just a basic document focusing on accountability, on sexual and gender-based violence in the context of terrorism. So very focused and narrowing it down to this specific topic. We have supported the study while entering the Security Council, where we were sitting for the last 2 years. And unfortunately or fortunately, the study was discussed in December 2023, so after the 7th of October, and was still very under the impression on what had happened. So it created far more attention that we had expected for rather sad reasons. But nevertheless, it brought states to the table to discuss the interlinkages between SGBV and terrorism and accountability in that regard. And I think 4 main takeaways. What we have also heard from Erin before, that there are quite many legal and procedural limits, limited investigation and prosecution strategies. There is a state obligation to do so, but there is still a big variety of standards that are applied. And we see that still high barriers that affect victims' ability to access justice, effective remedies, and reparations, to look at the whole package of measures that should be taken. And well, echoing Erin, we recommended to adopt and amend legislation in line with international standards, because it's the international standard that sets the benchmark. And we would kind of to see a group pressure to the top to raise the standard in the national jurisdiction. And of course, also aiming from a Swiss perspective at universal jurisdiction for core crimes on the international law. This would be another important goal. And interesting for you, I hope, is that we all agreed that to assure a victim-centered approach, the active participation of civil society organizations has proven to be vital and crucial.
I agree, and I agree that the international level has to be like leading the way for states and for civil society as well. So thank you, Sandra. And let's shift our focus to historical lessons. So Tanya, looking at the Bosnian War, CRSV was a defining feature of the conflict, with both state and non-state actors perpetrating these crimes. So can you give us a brief overview of what took place and what made these crimes particularly distinct?
Yes, and first of all, let me just thank the organizers and the Commission on Status for Women. It's a great honor to be among my colleagues today. The Bosnian War took place 1992 to 1995 and was noteworthy for rapes of approximately 50,000 women, girls, some men, and boys. their bodies became a target of war, systematically carried out against mostly Muslim women, but also women of other ethnic groups, including Croats, who were raped by Serbian armed forces. Noted about this war was the prolonged detainment of women who were placed in designated rape camps. Thus, women who became enslaved were repeatedly raped over extended periods of time. Actually, the International War Crimes Tribunal for the former Yugoslavia estimated that the vast majority of the women, 20 to approximately 50,000, were raped, and 80% of those were raped during prolonged periods of detainment. These rapes were carried out by militia as well. Militia members who were irregular, and they carried out a campaign of terror and in plundering and rape, particularly in eastern Bosnia. These malicious soldiers were under the command, so to speak, of Slobodan Milosevic, who was president of Serbia at the time. And one of the most notorious of the militia was Archon Tigers. And Milosevic seemed to prefer the militia because he could obfuscate, he thought, his command responsibility. Archon was a Serbian nationalist who led the Archon Tigers, obviously, and not only raped, but plundered, pillaged, razed housing, and blew the roofs off houses so that people could not occupy and remain in their homes, and therefore they would occupy that territory and ethnically, in effect, ethnically cleanse the population. I would add that the Bosnian forces' control of the war continued for 3 years, and the Bosnian CRSV could apply, I believe, in this context, could apply in many different wars that are actually happening right now. Shall I get into that?
Yes, please.
Okay, so I would say that, first of all, CRSV in the Bosnian context could certainly apply to what happened on October 7th in Israel, and certainly to the Israeli hostages, both women and men. My research reflects that detainment results in sexual assault by lawless criminals. There's nothing here that would be confusing to anyone. There are people who are detained and then they are raped. Bosnian CSRV also applies without question to the Ukraine war, as it just passed its 3rd anniversary. And from the first week of the war, rapes were being reported. And later on during the war, men were also being targeted. And it was reported by local journalists it has been reported by local journalists throughout the conflict. But we also know that there's been a lot of territorial changes inside Ukraine between the warring parties. And so whether or not people have been detained for long periods of time maybe remains to be revealed, I hope, through a trial for the perpetrators. There's no actual extent, we don't know right now the actual extent of the crime in Ukraine, but it is absolutely been demonstrated by Russian forces who were later found to be carrying Viagra, that they have been raping Ukrainians, both men, women, and children. I also think that the CSRV Bosnian experience could apply, unfortunately, to the renewed war in Sudan, where the suffering of women has recently reported that women are being raped multiple times, 13, 14 different times, maybe even more. And because of their suffering, they are resisting through credible news reports of engaging in suicide pacts. This is really horrific. And Sudan is experiencing this wave of CRSV again. And it is also true that CSRV victims rarely get interim care, as Aaron just pointed out, by the Ukraine government. And that is certainly a breakthrough in a departure from past practices.
Wow, thank you, Tanya. And now let's examine the international legal framework. So Ruth, existing international protocols provide important tools for addressing CRSV, but gaps still remain. So what do you see as the key deficiencies and gaps in the current framework?
I think we can generally say that while there is definitely increased awareness, and there is also a sense of even multiplicity of various international frameworks and protocols and guidelines, we are all aware that in practice, it simply doesn't work. I mean, even the first successful prosecution for CRSV by the ICC took more than a decade to materialize. And so far, there has only been like 1.5 successful convictions for CRSV in the ICC. So something is not really working, and I think we can divide between what is lacking in the protocols themselves and what is lacking in the implementation. And we all know that it's always recurrent theme in law, the gap between the law on the books and the law in action. But when it comes to the protocols, there's the most probably most known and highly regarded as perhaps the leading protocol in this area is the 2014 updated in 2017 the UK International Protocol on the documentation and investigation of sexual violence in conflict, which was created to establish really best practices for documenting CRSV, but it has been criticized for not giving enough attention to forensic evidence and for being largely geared toward international courts rather than the national level prosecutions where most CRSV cases are actually being handled. And this gets us to the deficiencies both in the normative framework and the actual implementation on the ground, because the reality is that many legal systems specifically in conflict affected countries, they lack trained forensic experts, and they are unaware of standardized procedures to handle sexual violence evidence. And all this makes prosecution extremely, extremely difficult, if not, in fact, impossible. And then there are many sociocultural barriers that affect the evidence collection, because we all know that CRSV is often deeply stigmatized, and this leads to underreporting and reluctance among survivors to engage with legal processes. And in many conflict-affected areas, particularly in them, gender norms discourage survivors from coming forward, which also exacerbates the difficulties in the implementation. So in large, there's really gap which mostly relates to the difficulties in implementation. And of course, I didn't even talk about resources. However, what we also note in our work, particularly in relation to taking October 7 as a test case or as a case study, we also note that there is gap in the normative framework, which most of the protocols do not relate to, do not address. They focus on the documentation and the collection of evidence, forensics, etc. And they relatively less address the issues of the substantive law that is required when wanting to successfully prosecute for CRSV. And maybe we can address that in relation to October 7.
Yeah, exactly. So my next follow-up is looking at the case of October 7, what unique challenges does the situation present in terms of seeking justice, and how do they highlight gaps in the existing protocol, as you started mentioning?
So October 7 presents unique case where there's ample evidence that undoubtedly point to the fact that sexual violence was used as a weapon of war, yet there are no survivors of the sexual violence that was perpetrated on October 7 who are alive and able and willing to speak and to step forward and to give testimony as to what they had undergone on October 7 as victims of sexual violence. And in addition to that, there is also lack of physical forensic evidence in the form of tests for actual forensic materials that were not extracted from the bodies of those who had been subjected to sexual violence. So these would be the quote unquote, the conventional evidence that is sought for when attempting to successfully prosecute for sexual violence in conflict. And by the way, it definitely does not guarantee a successful prosecution and conviction, right? As we mentioned, there are very, very few convictions on the international level for CRSV. But in Israel, our starting point is even below this threshold for lack of survivors, speaking survivors, and lack of the conventional hardcore physical forensic evidence. And we don't need to go into the reasons for that. I mean, we all know they were mostly murdered, and so the state authorities were not aware of the, as you mentioned, Tal, at the beginning, that nobody was prepared for that. There were no protocols to extract evidence and how to deal with this kind of crime as a part of a terror attack. But this is the reality. So what we are attempting in the Dinah Project among other aims that we took upon ourselves, is to develop the ways to show that existing normative legal framework in criminal law and in international criminal law does exist to allow for successful prosecution even under these circumstances. But there is also need to incorporate these insights in those protocols, in giving some directions, not only on the more technical side of evidence gathering and documenting, etc., but also on the normative side, and with respect to training prosecutors and training also the judiciary in understanding how CRSV is different from peacetime sexual violence. And so the evidence should be examined from a different perspective, in a different lens, and continue in that direction.
Thank you. And just a short follow-up on this. Can you share how does politicization of CRSV impact efforts to hold perpetrators accountable?
So the politicization of CRSV is actually what really exacerbates the challenges and the difficulties in successfully seeking justice, recognition, and justice, because, and again, Israel, October 7 is a very pertinent case study to that, as we saw immediately on October 7 and in the following days, the amounts of the denialism and the fake and the downplaying and putting it all in the context of the usual victim and villain in the Israeli-Palestinian conflict, completely obscured the truth of the reality of what has happened, and made it particularly difficult to conduct the international investigations. It's just enough to see how the special representative of the Secretary General, Pramila Patten, in her report of March of last year, took pains in delineating the exact steps of their documentation and information gathering, to also show how they actually refuted some of the disinformation that was published, that was spreading after October 7, in order to, in advance, block any possible criticism of her report. So this is really a pertinent example of the politicization, but it's present in all conflicts, and whenever sexual violence is taking place and is used as a weapon of war, it is immediately becoming the most contentious element in the international conflict, where both sides, both the perpetrators and the victims, use political arguments to refute the other side's claims and arguments, it affects the work of the prosecution, it affects the work of seeking justice, it affects litigation, makes and only adds to those already existing impediments, which we mentioned before, the cultural barriers, and of course, obviously, the evidentiary barriers.
Thank you, Ruth. Now shifting our focus to accountability and prosecution. So Erin, based on your experience, can you share what strategies could help overcome the main barriers to prosecuting perpetrators? But you talked earlier about what can be done before an event of CRSV. Can you share a little bit about what do states should do after?
Yeah, and let me say, I think we've touched on some of the investigative forensic evidentiary issues. One other thing though, let me take it from two perspectives. I'm gonna start with sort of the prosecutors, and then I'm going to talk a little bit about survivors themselves. But from a prosecutorial standpoint, I do think that one of the main barriers to prosecuting perpetrators of CRSV is that there is still a reflexive view to prosecution of conflict-related sexual violence under specific sexual violence or rape prohibitions, which does not always, one, represents the actual reality of how CRSV is used. You heard Ruth refer to weapon of war. Rape and sexual violence are often in conflict tools to accomplish a illegitimate, illegal objective, and can be prosecuted differently. So one example is that sexual violence, when it amounts to, when it meets the threshold of ill treatment, inhumane treatment, or torture, qualifies as the crime of torture and should be prosecuted as that. It should be prosecuted, for example, when it's used as a form of discrimination, as the crime of persecution, which is, of course, within the Rome Statute and should be domesticated. So that's one of the things I think from a prosecutorial standpoint that oftentimes we fail to understand, that conflict-related sexual violence is the crime of sexual violence, the crime of rape, but it also can be other international crimes, and it needs to be prosecuted in that manner and with the evidentiary thresholds of those crimes. The bigger issue, though, around barriers to prosecution has to do with the well-being and ability of victims themselves to go through the process. And one of the most important things to understand about any justice and accountability process is that victims have to be mentally and physically strong enough to go through those processes. Otherwise, they're not going to be able to participate in seeking justice for themselves in a meaningful manner. And what that means is that it is incredibly important that states meet their obligations to respond to conflict-related sexual violence by providing holistic care immediately, meaning not just physical care, but also psychosocial, operating at the community level to address any versions of stigma and discrimination that may exist, but also looking at various harms that can arise within family structures that can be incredibly devastating to survivors and make it very difficult for them to have the mental energy to engage with justice processes. So I think understanding that justice processes for anyone, any crime victim, is traumatizing and exhausting. And we all know that it's something that people hesitate to put themselves through. When you're talking about someone who has survived conflict-related sexual violence, often perpetrated in an incredibly brutal and public manner, the necessity to provide psychological care and medical care, physical care, to have that person be strong enough is even more paramount, because otherwise people simply are trying to survive. They're trying to recover from this horrific thing, and to ask them to engage with the justice process is oftentimes too much. And that's a very serious barrier that we need to have a truly survivor-centered approach that takes a trauma-sensitive approach at all stages of state actions.
That is so interesting. And if I understood correctly, you're not talking solely about the victim itself, also about the family of the victim. So that's very interesting. And I think that is kind of a different approach from what we've heard until now. So thank you so much. And in your view, what is the role of international tribunals versus national justice systems in addressing CRSV?
They're both important, and I don't view them as being in conflict. I view them as complementary avenues for justice. But maybe, Tal, if I can just give a short reflection of my time with the International Criminal Court. When I was with the Trust Fund, I did a lot of the final interviews of reparations beneficiaries. Reparations come at the very end. So you have your investigation, your prosecution, your appeals, and then you have reparations. What that means is that these are people who had engaged with the court on different levels for over a decade in many situations, from the beginning of opening of an investigation all the way through to reparations. And so I did a lot of the one-on-one interviews with them about that experience with the court, what their degree of satisfaction was, what they wanted sort of to express to the court as a final statement. And what struck me is that for so many people, and everyone's experience is individual, but this is something that was quite marked in how much it came up, was that there was a degree of ambiguity about the court, in the sense that there was a great deal of appreciation and understanding that justice otherwise would not have been possible because of the domestic situations in which the crimes were committed, but that many people expressed frustration and sadness that they could not receive justice from their own government. And I think that this is a critical aspect of, human rights and rule of law underpinning is democracy itself and the relationship between citizens, nationals, and our states and our governments, and that a government is of the people, for the people, and by the people. And that means that it matters that we can, if we are harmed, that our state has the systems in place to provide justice, that our state is willing to act on our behalf when crimes are committed against us. And so I think that the International Criminal Court and international institutions, they are ultimately and should be viewed from the context of complementarity of courts as last resort, and that justice generally, unless there are very serious due process and rule of law issues, does need to be as close as possible to victims themselves, but also to the affected communities. It's very hard for people to understand what happened and internalize that and communicate as a community, as a group, when justice is taking place in another country, in another language, potentially even under a different legal system than you are familiar with. So basically, when at all possible, justice should first be at the domestic level. I do believe that. And when it cannot be, the International Criminal Court and other ad hoc tribunals are incredibly important to ensure that there is no impunity gap and that everyone does have access to justice.
Wow, thank you for that. I think it was crucial for us to hear that, how important it is to receive a validation from your own state about what happened to you, and it just gives more affirmation of what we are continuing to do in our efforts here in Israel. So thank you for that. Tanya, in the handbook that you co-authored, you wrote that thousands of Bosnian victims are unlikely to obtain justice during their lifetime. And unfortunately, like we just said, this is not unique to Bosnia. So what recommendations do you have for victims from other cases, as well as for the NGOs that support them? Tanya?
Yes, sorry.
No,
Can
it's
you
okay.
hear me?
Yes.
Sorry, Erin really covered the basis quite well there. Let me just say that, yes, it's true that thousands of CRSV victims in Bosnia, and I'll point to the case in Kosovo, which had the unfortunate experience that the International War Crimes Tribunal for the former Yugoslavia was an ad hoc court. Ad hoc courts have end dates. And unfortunately, their war in 1999 overlapped a short period of time with the end of that ad hoc court's ending. therefore, there were 20,000 rapes in Kosovo, and only one conviction was applied to commanders. There were 4 commanders who were found guilty of command responsibility for the rapes, but there were no individual cases of victims being able to access a court to obtain justice in the classic manner that we've been discussing. I think now what is emerging, and I would love to hear also from Aaron on this and others who may have knowledge about it, is that you're seeing the emergence of third-party state prosecutions. In other words, if your domestic court is unable to prosecute on your behalf, we're seeing third-party states. For example, Germany has prosecuted an ISIS fighter for the trafficking and rape of a Yazidi woman successfully. Those are opportunities for other maybe perhaps members who have our state party signatories to the Rome Treaty. They might take on cases themselves. Therefore, we're talking about expanding what is called universal jurisdiction. There's also a case that's happening right now in the Balkans. The perpetrator was a fugitive, was arrested in Montenegro, and Montenegro has taken that case on, and they are prosecuting because the man was from Montenegro, and they stepped up to take accountability and help bring this victim to some resolution of justice. I'm going to be really honest. It was mentioned earlier that there has been a 50% increase in these crimes. When you look at Ukraine alone, I know they have approximately 250 cases prepared to take more than likely to the ICC, because the ICC had opened up an investigation in 2014 when Crimea was annexed and rapes occurred. And then the prosecutor announced he was reopening that case and adding to it. It's a question of capacity now. How many countries are experiencing this horrific crime, and how many countries have the capacity? So it's a capacity issue too, that is very, it can be challenged through different ways. Politically, they could lack the resources, they could be a poor country. Where do they get the assistance? Where do they get the help? What's interesting is that there are in the Balkans 3 national war crimes courts that have taken up the cases that weren't actually prosecuted, and there are cases being prosecuted in Bosnia today. But because Kosovo is not recognized by Serbia and they do not have an extradition treaty, so therefore there's no cooperation, they took the step in Kosovo 2 years ago to try assailants or perpetrators of a CRSV through absentia. And they did, in fact, convict someone last year who has been a fugitive, who's not been brought before a court because there's no ability to do so in Kosovo. So this is an example of where can the world step up to meet this burgeoning crime. And I do want to address before I go, before we all go or get into a further conversation, is that some of the victims in Bosnia didn't exist at the beginning of the war. They didn't go through actual rape. They were born because their mothers were raped. And Bosnia became the first country in Europe 2 years ago to pass a law that said children born of rape were to be defined as civilian war victims who were able to and should receive benefits from the state. And the Federation Parliament passed this law. It was also passed in Brčko, which is a different governing entity within Bosnia. And now the civil society side of this, where civil society helps back victims, they have organized the Forgotten Children War Association, and they have put a face to this issue, in a way breaking some silence. It's been estimated 2,000 to 4,000 children were byproducts of war rape in Bosnia. And these young people who are now actually really in their 30s, because we're talking about 30 years ago, the war ended, have stepped forward as strong advocates on behalf of the community. So I think that's one of the ways I'm looking at it. How much can third-party states step forward? It remains to be seen. It has been discussed in conferences in Europe that Rome Treaty signatories might be able to step forward. I do not see the United States stepping forward right now under the current government, which is regrettable.
Thank you, Tanya. I think it's very interesting to see your historic overview and how you can say or point at various stages of years that things have changed and that the international community has stepped up and what more should be done. So thank you so much for that. Sandra, from a policy perspective, can you share what improvements do you hope to see on the state level to ensure better justice and support for CRSV victims?
Oh, thank you very much. It's quite difficult to come in at this stage, but one thing also relying to what Tanya said, just to a later statement of how third-party states could come in. One is to keep them committed on the issue of CRSV. We have seen over the last months horrendous blows to the rule of law and international law-based orders, seen a shift to more kind of a rules-based order. This has an impact on states' engagement on accountability and fighting impunity. So we need to keep states close to the issue, and of course Switzerland is committed to do so. A second thing, how can we assure accountability as a third state? It's universal jurisdiction. In Switzerland, we can prosecute war crimes and crimes against humanity and genocide, but even also particularly when it relates to sexual and gender-based violence, because it's a universal jurisdiction. So we can, in addition to an ICC, for instance, prosecute those crimes. Universal jurisdiction, however, requires universality of human rights and an international standard in national legislation. So this would be an area to focus on, to encourage other states to raise the bar, raise the level of ambition, make sure that our legal systems are compatible and that we can enhance the possibilities for universal jurisdiction. I think that's what we can do. And also what we've seen in the Malta roundtable, but maybe we'll come to that later, that it needs kind of a village. We need policymakers, legal experts, prosecutors. More and more is going on in the digital space, so we need that expertise as well. Survivor advocates who tell us where to help us identify where the gaps are. So particularly appreciated was Erin and Ruth were saying in that regard. So yes, I've taken this up so that's from a state's perspective where I see where we could come in.
Thank you. I think it's so important to note that we need other countries to be and other states to be to think how important this issue is. So it's not only, you know, lobbying or advocating to your government or to your state, it's also working internationally with other actors in the scene. So I think that's a very interesting highlight for me personally. And as you just mentioned at the policy roundtable on advancing accountability for CRSV, linked to terrorism that was in Malta last November, can you share a little bit about the key takeaways from that table and how do you see them influencing future policy?
I think a lot has already said, maybe filling in some gaps, if I may. It has been a long list of recommendations, but one I think struck me particularly. My division is covering human rights law, international humanitarian law, and counterterrorism law, anti-trafficking law. And under all this, sexual and gender-based violence can be prosecuted, but there are different obstacles or different procedural aspects that need to be taken into account. So for the victim, it's the violence and the crime that happened, but for the prosecutor, the qualification is an issue. And some legal instruments or some legal package of instruments make it easier or more difficult to prosecute sexual and gender-based violence. So this is something that I think might require further thinking. And often what we see, particularly in counterterrorism cases, that counterterrorism charges are prioritized over SGB-specific prosecutions. So in the end, we have very little cases that do focus on CRSV because there are other crimes, other acts that are seen as more important or more easy to prosecute. And that would be another impact, to have more cases dealing with sexual and gender-based violence, to have more to report on, more to learn. It will also feed into the practice, into the studies, into the training also of people working in the legal sector. Then widening the package, so to say, I think that would be my last point, that we mentioned it before, include reparations. Erin has been talking about the ICC Victims Trust Fund, build truth commissions, the cumulative charging strategies, that too much focus on other core terrorist crimes than SGBV. And in the end, it's just about dismantling the systems that enable gender-based terrorism, gender-based violence in the situations of war and armed conflict. Yeah, thank you.
Thank you, Sandra. I think what stuck with me is the hierarchy of prosecution and how important it is to raise awareness and to advocate to have more cases of CRSV. So thank you so much. And we have just two last questions, so stay with us. Tanya, can you share, beyond legal justice, collective memory plays a crucial role in how societies process and acknowledge sexual violence and conflict. So what can we learn from the way Bosnia and Herzegovina, or maybe Rwanda, have integrated CRSV into their national memory?
Well, this is a very interesting question on Bosnia. And I cannot overstate how significant the Srebrenica genocide is within the country and how it actually has cast a more or less a silence around the women that were raped. And that was because the mothers of Srebrenica, have formed, that's actually an NGO, it's an association, and these are the mothers of, there's like 6,000 women who lost husbands, brothers, uncles in the Srebrenica genocide, and they chose to make their loved ones the priority, and they did not talk about being raped. And actually, on the day of the genocide in Srebrenica, the women were taken away when the men were separated from the women, and the women were taken to the White House and they were raped, but they never talked about it. Similarly, as a whole, the country did not talk about it. And I was there in the early post-war years. And I want to give credit to a feminist filmmaker, Jasmila Zabanic, who produced in 2006 a seminal film entitled Grbavica. And Grbavica is an area outside of Sarajevo. It was behind the front line. And the scenario of this film is this mother, this woman, has had her daughter because she was raped. She did not give her daughter up. And the daughter discovers that she's a byproduct of rape. Jasmila, this was an award-winning film, but what she did for the country to this day inspires me. And that is, she screened this film in the largest facility, where the largest audience could be. It was an Olympic facility, and there were like 7,000 people in there. And that film broke the silence. It really broke the silence. Jasmila went on to win the European Film Awards just 2 years ago. Kovadish Aida, Where Are You Going, Aida, which is about the Srebrenica genocide, and you get to a moment in the film where you know the women are going somewhere and it's not good. It's not gratuitous violence. It's an excellent film. I recommend it to everyone to learn about a feminist perception of how her country was torn asunder. So what's interesting, I was a witness just this last year when the UN moved to pass a resolution to highlight and commemorate and recognize the Srebrenica genocide on July 11th. Every year it was passed, and I was sitting with the leader of the Srebrenica mothers, and she spoke about the rapes. And I was deeply moved. I mean, they never wanted to talk about themselves. They wanted the attention to be on their loved ones who were spread in mass graves all over the country. And I intended to talk about it, and I did. And I acknowledged her and said, I am deeply moved that you are speaking about this today. And I went on and gave a very short overview about what took place in Srebrenica on that day to the women, and the women really suffered. I would add that I do believe, I spoke about the young people, the forgotten children. They're giving voice to it. They're breaking the stigma of silence too, by just virtually showing up and being visible. And I want to give credit to International Trial, which is an NGO that has worked very closely with a lot of the survivors and helping them go through the court process. And there's indeed a psychologist, as Erin was talking about, there's a psychologist that prepares witnesses to go before the War Crimes Court in Sarajevo. I am certainly not an expert on Rwanda, but I will say this. I've heard from many of my colleagues who are, that I am aware that the Rwandan women really have transformed that country. Many are elected, many serve in the parliament. They're really movers and shakers in that country. I know a number of the people who also created the museum and worked with the survivors. And these are really incredibly empowered women, and women who have really transformed Rwanda in post-war in ways that I do not see consistently across countries that are post-conflict, for sure. But I don't really want to get beyond my authority, and I just want to share that that I hear wonderful things and have read about it as well. And I have great respect for what they have done in post-conflict.
That's amazing. And you know, they say that being an optimistic is a stand, is an active decision. So I'm deciding to take that from your things and from your talk, how things could shape for the better after a conflict. Thank you
Just
so
let me add one more thing. I want to do a shout out to President Osmani of Kosovo. She has been a champion, a leader. She appointed Vasvia Goodman, my friend and survivor, as a special envoy for conflict-related sexual violence. Vasvia took me to Israel last year. I accompanied Vasvia to Israel last year. That was part of my work in the research I did on Israel. And I have to say that President Osmani has been a driving force on advancing women's causes and about addressing the needs of the survivors. And I would also add, and this is also a shout out to the United Nations, that we do have the Women, Peace, and Security Architecture. And I think it's incumbent upon countries, and I know Israel itself has put this in their report, that there needs to be full implementation. And that we're seeing that happen in some countries and not in others. But I know that there are people working very, very hard to do this. And I think it's really, really important to do it to advance women's equality in general.
Thank you so much. Ruth, last question is for you. Can you maybe answer this question? So criminal prosecution is only obviously one pathway to justice, as we just spoke about, but are there alternative means for recognition and accountability? Are current international protocols sufficiently addressing these other mechanisms?
So I think that what we understood so far from the very broad overview of all speakers is that while seeking justice through litigation is regarded as the major step, as the major way to achieve justice, it is very, very difficult. And there are many, many hurdles and impediments along the way. And it takes a long time. And even though we do have the protocols, they are not always implemented. There is lack of awareness and everything that we said so far. And in general, in the world of law and justice, in recent decades, there are more and more, there's more and more awareness that litigation is really not the only path. And justice comes in many forms, and there are many doors to this hallway of justice. And even mentioning, as Tanya did, the Memorial Day for Srebrenica is a very, very important form of achieving justice, even though it is perhaps not directed at the individual victim, and it is not requiring, it is not punitive towards an individual perpetrator. The need for justice is also the need for the collective. And that is, in fact, one of the aspects that make CRSV different from the form of everyday sexual violence against women or gender-based violence against women. When sexual violence is done as a form of a weapon of war, it is directed against the collective. It is done by the collective against the collective. And achieving justice through litigation is very often based on identifying a specific victim, even though we are arguing against sticking to that. But you actually do need the specific perpetrator, whether it is the commander or the minor terrorist, whatever. You need to identify them. And even those trials in absentia that are taking place in Ukraine right now, they are able to do that after they have identified the specific perpetrators, sometimes through the digital evidence. But it is, what I'm saying is that it's the individuals, but the other forms of justice that are achieved to the collective can be, for instance, through the international reports of investigative mechanisms, of inquiry mechanisms, which are not necessarily bound by the very, very strict rules of evidence of the criminal law in litigation, even though they also follow very firm methods, a methodology of collecting evidence and corroboration, et cetera. But these international reports, they do serve the purpose of recognition, of validation, of acknowledgement, which is very, very important to the collective, to the whole collective, and also to the individuals. And again, I'm going back to experience from other forms of criminal law and justice, and post-war criminal law and justice, what we know as restorative justice, what we know as transitional justice. These are all ways of recognition and validation that do not necessarily go through specific litigation. And I think that this way of achieving justice can and should be more developed as it is right now. I don't think that the existing protocols in the 2017 UK protocol, there is reference to the different paths of achieving justice, but I think that these should be broadened, they should be widened, and they should be more developed as an alternative for the litigatory path, which, as I'm not saying, of course, to give up on that, but they should be recognized as no less important.
Thank you so much. Unfortunately, we don't have enough time for the questions, but we will share our emails and the emails of the panelists after, if they agree, and maybe we can have another conversation later on. I want to sincerely thank each and every one of you of your invaluable insights and for your dedication for seeking justice for survivors. This conversation has highlighted the urgent need for action, both in strengthening local frameworks and ensuring that justice is not just an ideal, but reality. So I want to thank all of you for being part of this critical dialogue and for bringing optimism to this critical story. Thank you so much, and good night.
Thank you, Tal. Thank you to all the participants and to the audience.
Thank you so much, everyone.
Thank you. Bye-bye.
Yeah, it was really good. Thank you very much. Appreciate it.